Hi, everyone. Anyone who's just joined us, we are here at the TIE Global Summit 2020. We've had quite a day, and we're here back with another keynote address. Now, this one is an interesting one. This one talks about structuring your startup for US financing. And we have none other than Mr. Bhatt, who has been an integral part of the committee at TIE Hyderabad, who will be introducing our keynote speaker. Over to you, Mr. Bhatt.
Hey, thank you, Gunjan. That was lively. And hey, Joe, welcome on board for this global summit. And I have heard quite a few things about you from New York chapter that audience can't wait for you to share your experience with startups, fundraising, especially US facing startups. So just to give you the audience an overview, Joe Daniels has done hundreds of deals when it comes to M&As, IPOs, startup fund closers, and he has diversified industries, including technology, life sciences, and consumer companies. I would say he's a 360-degree lawyer for startup ecosystem. He has represented the VCs, he has represented PE funds, he has represented startups of all the stages. So welcome, Joe, for this conference, and it is all yours. We are eager to hear you.
Thank you, Bud. Can I share my slides?
Yeah, sure.
Okay, let me share my screen. Okay, can you see that?
Yeah, all good.
Okay, so good morning, everybody in the West Hemisphere, and good evening, everybody in the East. My name is Joe Daniels. As Bud said, I'm a partner and the co-chair of the Venture Capital and Emerging Companies practice at McCarter & English. This is my Structuring Your Startup for and Raising Financing by U.S. Investors sort of mini talk. I think I have about 20 minutes. Is that right, Bot?
Yeah, that is correct.
Let's just get right into it. So a little bit about my firm first. So McCarter & English is a 175-year-old law firm in the U.S. We represent startup to Fortune 50 companies. We have a department basically for everything that a business would need. That is things like intellectual property, litigation, real estate, tax. And I'm in the corporate department. We have about 400 lawyers and 9 offices throughout North America, but we have a global practice because we've been around for so long and we've been doing deals all over the world. I myself have taken, for example, in 2012, an Indian private limited company public on the New York Stock Exchange with UBS and Deutsche Bank as underwriters. And we have represented startups founders forever, including Thomas Edison here in the US. My VC and emerging companies practice focuses on formation, financing, growth, and exit. So that's everything from one person forming a company in the US to raising angel and venture capital financing, expanding through acquisitions and partnerships and commercial agreements, and then exiting through an M&A deal or an IPO, usually in the technology, life sciences, and the consumer sectors. We're usually highly ranked in the pitch book, which is the authoritative source of deal flow. We represent thousands of startups and funds. We did last year. I'll just stick with this year. 161 deals so far for about 7.2 billion in the first 8 months of 2020. And we also have a strong intellectual property group. In case you're interested in protecting IP in the US, about 120 lawyers. They do the patent, trademark, and copyright, prosecution, litigation, and licensing. Over 100 litigators ready to sue people all over the US and defend you. And just a little bit about me as well. I've been doing this for 25 years. When I came out of law school, I joined the group inside of a law firm that took Netscape public and sold it to AOL in the Silicon Valley. And here are some of the bigger companies that I've represented. I'll just highlight, Autodesk, Invitrogen, Monster, a bunch of private equity venture funds and investment banks like Credit Suisse and Morgan Stanley. So I am familiar with the whole life cycle. So here's our agenda today. We're going to focus on what type of entity should you form in the US if you're trying to raise money there. How do you protect your equity with vesting? What kind of equity grant should you make to your team? What kind of service agreements should you have? Other major legal issues that you should fix before you raise money. And then talking about how you raise money and what the typical terms of deals are. So the first slide, let's just dig right into it. I represent people all over the world who are try to operate in the US and then try to raise money here. And the bottom line is that US investors are still very prejudiced towards investing in a US Delaware corporation. That's just the way they think. It's easy for them to understand and predict, and there are numerous tax reasons for that as well. So we usually say, hands down, from the Silicon Valley to New York City, the U.S. C corporation is the best choice for a venture model company. The other major type of company that people form is an LLC. So don't do the LLC, do the C corporation. And here are the two major reasons. The angels and the venture capital firms prefer the C corporation because they do not have pass-through gain and loss for tax purposes. One major reason for that is that the not-for-profit companies that often invest in the venture funds do not want to receive the profit from your successful business to go through the venture fund into them, which causes them to have a penalty tax. Also, the fund is not really set up for that in the first place. Then there's the and angels don't like it either. The last thing an angel wants when they make an investment in you is to receive a tax bill, but no distribution of cash, because most startups never distribute their money. Then there's the qualified small business stock exemption in the U.S. If the founders are living in the U.S. or if they move to the U.S., this is going to be important for them from a tax perspective. It may actually also play out if you're somewhere else, like India, Singapore. Basically, the first $10 million of gain on the sale of your stock is exempt from U.S. capital gains taxes. If you ever are in a position where you would otherwise have to pay that because of where you live, that's a $2.5 million benefit. And then we recently lowered our corporate tax rate to 21% in 2017, but we'll see how long that lasts under the new administration. And then there's always the question, which state should be incorporated? I'm just going to try to make it simple. The answer is Delaware. Don't think about it too hard. You can't lose with Delaware. Why? I think the numbers are actually out of date. It's more like 75% of U.S. public companies, probably 70% of the Fortune 500, 90% of new IPO companies like DoorDash just went public today. Other recents, obviously Palantir, a big company like Twitter, those are all Delaware. And the reason why is because all of the U.S. investors and bankers and lawyers all prefer Delaware because they know it like they've memorized it, whereas they do not know the laws of the other states. So some people like accountants or whoever may try to convince you that it should be some other state, they're probably wrong. Okay, so there's two major types or groups of documents that are important to put in place before you try to raise money if you have a U.S. operation, or even if you have an operation in the U.K. or in Bangalore. So first, equity documentation. You have to get that cap table papered up. For the three major reasons here. You avoid disputes between the founders. Very often, you don't have things in writing. You can have long, drawn-out, expensive disputes. It's a big tax issue in the U.S. if you issue the equity too close to a financing round, because then you could be creating taxes for yourself. And investors all want it in place. They want it. In fact, they'll ask questions about why it's not documented if it isn't. And the documents are very simple, and all the law firms that practice in this space have standard forms. In other words, it's a standard form from Florida to Washington State, Maine to California. What types of team equity are granted? This is sort of a confusing point for a lot of people who come into the U.S. and try to issue stock to their team. It's basically two types. We call it restricted stock, which is just ordinary shares or common stock. And then there are stock options. And do not think about these other esoteric instruments like, any other type besides restricted stock and options. I'm not going to even give an example. And the basic rule is that before you do a priced equity round, which is when you sell your stock for cash, usually that's preferred stock, you usually grant the restricted stock and you grant it at par value or some very small amount, close to $0. So the idea is person getting in then is a founder, someone close to the founder or the time when the company was founded, and they're getting the stock for virtually zero, and then they hold on to it forever until the company is sold or goes public, and then they sell it. And they're only paying capital gains on that. It's a great deal. It's the best tax deal in the U.S. for holding stock. But if you have vesting on the stock, then you have to file something with the IRS if you're a U.S. tax person within 30 days of buying it. After the priced equity round, then you go to the stock options. Because I see the reason why I point this out is because I see a lot of people forming companies with lawyers who do not understand the emerging company space, and they will maybe grant two people, the founders, common stock or restricted stock, and then they'll start granting options to everybody else. And it creates a very messy tax situation unfavorable tax situation for that team, that original team. See if there's any, no. Okay, so the other key point about equity is that all equity for services in the US should vest on the schedule for a venture model, technology type, or life sciences company. Why? Basically, all the people on the team want other people's shares to vest, because if the other people leave early, then they shouldn't be able to keep all their stock. For example, if you divide your stock up amongst 3 founders, 1/3 each, and then one person leaves after 2 months, they don't deserve a full 1/3 of the company. You should be able to buy back all or a big chunk of their stock for virtually zero. Also, investors will want all of the shares of all the team members to be vesting, and they carefully look at the cap table and they ask you, who is this person? What do they do? Why do they have such a big percentage? Because they want everybody to stick around while you're building the company for 3 to 4 years. Usually the vesting schedules are 3 years. Here's a typical vesting schedule from the Silicon Valley for a founder: 3-year, 1-year cliff, which means 1/3 after 1 year, 1/36 each month after that. Somebody who joins later, like an employee or a consultant, 4-year, 1-year cliff, 25% after 1 year, 1/48 each month after that. Directors and advisors, 2 years on a monthly basis. And then you should consider the milestone-based vesting schedules, which means that, if your development team actually develops version 2.0 to the satisfaction of the company, then 50% of their shares vest. Basic concept, tying the vesting not to time or how long they're working there, but what their actual performance is. The other main basket of agreements you should put in place for everybody are the service agreements. All advisor, we have these different names for personnel, but I think under the laws of almost every country, people are considered either an employee or a consultant or a contractor. And the laws of the different countries and states within the countries treat these people differently, and there's different tax rules. So you have to have a different agreement for each type of person. In the US, we have advisors, consultants, interns, and employees. So we have a different agreement, but they all say 5 important things if they are the right form. Number one, you will not disclose the company confidential information, and you won't use it for any purpose other than the company business. And that includes, sometime after you leave. Also, you will assign over all the intellectual property that you create for the company to the company. So you can't later claim, well, you didn't pay me for that IP, or I actually invented that on the side, at home. And people do this all the time. Also, it prohibits the person, when they leave the company, if they leave the company, from stealing the customers and suppliers, talking badly about the company, even competing directly with the company, because in many cases, at least in the US, probably everywhere, people do this all the time, all 5 things. So you have to have provisions that prevent them from doing that. Otherwise, you might face your greatest team members working for your competition. You also want to tie the equity vesting to duties in the service agreement, the equity vesting I just talked about, to be able to leverage people to actually perform at the level that you expect. And remember, investors will all want all current and former personnel to have signed one of these service agreements, because they want to make sure that all of the IP is owned by the company and no one will ever have a claim against it. So very important. We usually recommend that people sign these documents as soon as they join, because it's too easy to forget. And other major legal matters to clean up before we get to fundraising: intellectual property. Remember to use non-disclosure agreements where possible to protect your trade secrets. So it's clear, the things that you develop, they don't belong to somebody else. Service agreements I mentioned. Consider filing for a patent, trademark, or copyright protection in the relevant jurisdictions where you operate. Most IP lawyers will give you a free consultation to talk about strategy for those protecting that IP. I know my partners will do that, patent partners. And you have to confirm the clear IP chain of title. That is, if someone else is coming on board that works at another company, be sure that you ask them about their current employment agreements, because they may not be able to share with you a lot of the trade secrets, obviously, of that company, or even things that they invented on their own, because it's unfortunately been assigned over to that company and it can't be used by you. Material agreements, where possible, have good lawyers draft and review your terms of use and privacy policy, your form of customer, supplier, distributor, and affiliate agreements. Other important deals, especially when there's any technology or IP involved, because people are very tricky in the U.S. about putting special provisions in agreements that basically take your IP. And you want to resolve any regulatory issues you have. Like, for instance, if you're a medical device or a biotech, you want to at least know the pathway of getting to being able to sell into the U.S. market, because investors will expect that you know it, and exactly, you probably already know that, but it's a good example, and try to resolve all litigation if possible. Okay, so how do founders, now that you've cleaned up everything, got everything set, how do you raise money at an early stage? So we usually divide in the U.S. the early rounds into pre-seed and seed financing. Pre-seed, where you're raising about $50,000 to $750,000 for about 1-10% of the company, and that's down the road. Usually that requires only strong founders and some level of product market fit. For example, letters of intent with big enterprise customers, adoption on the platform, like lots of people using the platform, subscribers, but no revenue yet necessarily. It's always better to have revenue. So this is, usually we used to call this the friends and family round. So it's difficult to raise at this early stage without doing a lot of networking or angel groups and that sort of thing. Seed financing, on the other hand, we consider that to be between, let's say, $500,000 and $5 million. Those numbers are a little bit out of date. Seed rounds can go on up to 10 million now because the parameters for the A round, which is the next level, have gone up to 1.5 to 3.5 million annual run rate. So you have to raise these seed rounds to build that revenue. So the requirements for the seed round are not only the strong founders and the apparent product market fit, but also some kind of meaningful traction, usually in the form of revenue in the U.S., meaning $10,000 a month of revenue, or $1 million of annual ARR. That's about the range that people look for. And the investors in these deals are usually wealthy individuals, people who have $10 million or more. That's not the requirement. You could have $1 million or more, but they're usually 10 million plus people, and so you have to use the right techniques to find those people. And then it's often a company-led round, which means you have to go to your counsel, ask them for a term sheet and the typical terms for that situation. That's why we're going to talk about those. And then your lawyer will produce that term sheet. Usually when you go sell that term sheet, if it's the right lawyer, the investors will buy it. So what are the different structures for raising money in the US? We call it a convertible note, a SAFE, which is a simple agreement for future equity, or preferred stock, usually called Series Seed preferred stock for the first seed round. So why would people sell these convertible notes and SAFEs? Maybe you've heard of them, maybe not. Three major reasons. You don't have to set the company valuation. It has a variable conversion price based on various calculations and formulas. So, for example, if the investors think your company's worth only $4 million pre-money, and you think your company's worth $15 million pre-money, which is one of my clients is in that exact same situation, instead, you could do a convertible note or a SAFE. You don't have to set the valuation. It's also cheaper. It's usually only $200-300 for a lawyer to put together one of these forms, and then you can actually negotiate them and fill in the blanks if you're qualified. So I say the fees are between under $5,000 as opposed to $10,000 to $35,000 potentially for the preferred stock financing. And then after you sell the convertible notes and the SAFEs, you can still issue that restricted stock, which is the much better deal from a tax perspective to your team. Why Series Seed preferred stock? Because the investors will insist upon setting the valuation at that low $4 million, like I mentioned. You may also have a bunch of convertible notes that are coming due, and you may want to convert them all so they can't all start clamoring for their money back. So that'd be another reason to raise the preferred round. So just what is a convertible note? I'm just going to boil it down to the simplest concepts so you have a general idea of what it is. Basically, it's a piece of paper that automatically converts into the next equity financing of a certain dollar amount, let's say $1 million. So if you're raising $750K in convertible notes, then usually the trigger to convert them would be over the amount that you raised. So let's say $1 million. So you raise $1 million in the next equity round, the notes automatically convert into that round. Originally, they were created so that they converted at the same price as the equity investors. But people began to realize, well, I'm funding your growth. I'm investing in you in 2020, and then you raise at the end of 2021 at a 10 million pre-money. Why should I pay 10 million? Because I got in when it was only 2 million. So they began to insert discounts, 10 to 25% discount to the round price. It gives you the benefit of the time value of money. But then people began to realize, well, if I get only a 10% discount off of 10 million, I'm getting in at 9 million. But I thought it was worth 2 million. Not a good deal again. So then people created the cap concept. So let's say if investors think the company's worth 2 million, you think it's worth 7. Why don't we cap it at 5? So if I actually end up raising it at a much higher valuation, 20 million, 10 million, even 7, they still get in at 5. And then the worst case for the company is the lower of the discount or the cap. Which means that the investor gets a substantial discount, whether or not you raise at a price that's above or below the cap. So that's why we organize this in terms of best for founder to worst for founder. Usually you end up with a note that it is either discount only or cap only. Try not to do both. The principal amount of the note that you raise is important because it determines the percentage of the company that you sell. The interest rate is slightly important, but really it's just sort of a number that people stick in there. Of course, it amounts to real money if the note is outstanding for many, many years. So you want it to be lower rather than higher. Usually the rates are between 2 and now. But keep in mind the term is only usually 12 to 24 months. So it doesn't accrue for a very long period. So, I wouldn't fight tooth and nail over that amount. That's why I put interest at the bottom of the slide. Next, the simple agreement for future equity. We always say this is better for the companies, for the founders. A SAFE is exactly the same as a convertible note, except it has no maturity date and it has no interest rate. So this is great. I said a convertible note is a piece of paper. Well, a SAFE is a piece of paper and it never comes due, right? And it does not accrue interest, so it can be outstanding forever. It does eventually convert into a priced equity route if you raise one. This is an instrument that has taken over the Silicon Valley because there are a lot of people in the Silicon Valley who make investments in safes, and they basically want to get the upside. And in a company that becomes a unicorn and goes public, and they don't really care much if the company dies. They see it as more of a binary investment election. Of course, there's many in between, and the other reason why is because the safe. If you're one of 10 investors of $100,000 in $1 million round as an angel, and it's in convertible notes, and that note comes due in 24 months, and 2 of the investors are asking for $200,000 back from the company, that can blow up the company's plans, operating plans, raising money. And I have clients who go through this all the time. They have to try to get the convertible note holders to extend the notes. It's a big pain. So eventually they said, why don't we just do away with this maturity date thing? It's all sort of a legal fiction anyway. But some investors don't get it. Some investors like to rely upon the maturity date to be able to try to ask for their money back, even though it seems to us that the last company to be able to afford paying back a convertible note is one that has not yet raised an equity financing and has already spent all the money that they raised in the convertible note round. But nonetheless, some investors don't get it. In that case, you have to sell them the convertible note. Or you get serious and you sell them preferred stock. So what is preferred? Preferred stock is what is the stock that fueled the growth of everything from Hewlett-Packard to Apple to Google, Twitter. All these companies raised Series A, B, C, D. SpaceX, I think, is on G, preferred stock, maybe higher. What is the most important term? The pre-money valuation. So, for example, if you're raising $2 million on an $8 million pre-money, that means the investors own 20% of the company after, because you add, it's basically the 2 over 8 plus 2 or 10, that's 20%. And that seems relatively simple. You negotiate that with the VC, they put it in a term sheet, you sign, but it's not that simple. There are all these little tricks and formulas, and probably the biggest tricks are the investor will ask that you adopt a large option plan pre-money, 10 to 15% of the post-money capitalization. And then they ask that you take all the dilution on that, because you're going to have the discretion to grant those, so you should take all the dilution. So you want to be careful. Usually you have to give into that because that's so standard in the US, but I recommend trying to make that lower rather than larger, smaller rather than larger. You can see in the cap table how it affects your percentage ownership. And you should also look out for them, investors trying to put convertible note and safe shares in the pre-money, and for basically causing the common stock to take all the dilution on that. You have to also watch out for people who calculate things based on a post-money valuation. So in the example I gave, they can say, okay, 2 million, 10 million post on a 10 million post money. So then if you have the opportunity to raise another 500,000 or a million, say a million in that trend, then the pre-money goes down to 7 because the post has to be the 3 plus the whatever the pre-money was to equal 10. The investment amount is also relevant because it determines what percentage the investors own, which I just explained. Then there's something called liquidation preference, and that's the key. One of the key aspects of preferred stock is that in the event the company is sold, they have the ability to choose to get their money back off the top before the common stock gets anything. Typically, preferred stock in the US in almost 99.99% of seed rounds, and even the A round is, in fact, all the way up to the C round is 1x non-participating. And then even in the B and the C rounds, it's only like 2 or 3, 4% that modify liquidation preference. So if people come at you with 2x participating, then look out. So I'll give you a hypothetical. So if we do the 2 on 8, 2 million raised on an 8 million pre-money, and then you sell the company for $5 million, then the preferred stock is probably going to take their liquidation preference. And because that's $2 million off the top, and then the common gets $3 million, right? Because 20% of
Joe,
the 5 is only $1 million.
Joe, sorry to interrupt. There's another panel waiting behind. If you don't mind, if you could conclude.
Yeah, I have probably 1 minute, 2 minutes.
Great, thank you, Joe. Appreciate it.
Okay, so finalizing that one hypothetical, if you then sell the company at 100 million, they're not going to take their 2 million off the top. They're going to take 20% or of 100, which is $20 million, right? That's the basic liquidation preference. There's usually no board seats, sometimes an observer seat, and you have to agree to blocking rights, try to limit the list or limit it to raising money or selling the company less than a certain valuation, and there's usually no anti-dilution protection. So that's it. No time for Q&A. Thank you, everybody, and have fun at the rest of the conference.
Thank you, Mr. Daniels. Unfortunately, we ran out of time, but it was, anyway, a really, really insightful session. Unfortunate that we don't have enough time for the quick Q&A, but I'm sure that the people, the audience, will reach out to you on your LinkedIn profile if they were to connect with you. Thank you so much.
That was good. I'll put my email in the chat box. Does that work?
We'll do that.